On Monday, the Supreme Court spoke against the use of the two-finger test on rape survivors. It deprecated the test, spoke about how the practice is regressive, has no scientific basis, and just needs to stop. But this isn't the first time that the Supreme Court has said it. In fact, the court declared this practice unconstitutional almost a decade ago, and that's exactly what I'll be telling you about in this episode of KYC, or Know Your Constitution. Now, let me just begin with telling you briefly what this test exactly is. As the name suggests, it is basically an intrusive test in which the doctor inserts two fingers into the vaginal canal of the rape survivor to check the laxity of her muscles and to determine or to check if she has been sexually active or not. This test is therefore performed on rape survivors to confirm their allegations and to check if the woman's hymen is intact. So it's also often called the virginity test. Now, in 2013, the Supreme Court intervened and said that the two-finger test violates the right of rape survivors to their privacy, physical and mental integrity, and their dignity. It asserted that rape survivors are entitled to legal recourse or legal options that do not re-traumatize them or violate their physical or mental integrity and dignity. This judgment was passed in a 2001 rape of a 14-year-old girl. The court was hearing an appeal filed by the convict. In the deposition, the doctor in the case had told the court that the rape survivor was habitual in sexual activities after conducting a two-finger test on her. But the court, of course, referred to its past judgments on how the sexual history of a rape victim cannot be used against her. This was, of course, a landmark judgment. In fact, in January this year, the Lahore High Court held that two-finger test was unconstitutional and relied on this 2013 Supreme Court of India's judgment along with other Indian cases to arrive at this conclusion. Now, a lot has happened since then, since this judgment was passed in 2013. For example, the Ministry of Health and Family Welfare also issued guidelines in 2014 barring the test in rape and sexual assault cases. Then in 2013, Section 53A was added to the Evidence Act. This provision says that the evidence of a victim's character or her previous sexual experience shall not be relevant to the issue of consent in sexual offences cases. Why is this related? Because, of course, like I mentioned, the two-finger test is often called the virginity test, which shows a woman's sexual history, which is then used in rape cases or used to be used in rape cases. So the Supreme Court, of course, since 2013, after that and even before that, has often spoken about and against the two-finger test, but also against the usage of a woman's sexual history to sort of talk about the credibility of her rape allegations. The court has said that these two cannot be related, and the credibility of her allegations cannot be questioned on the basis of her sexual history. However, this hasn't stopped the test from being used. This is what the Supreme Court noted in its judgment passed on Monday, saying that it is a regrettable fact that the test continues to be conducted even today. And the court made some very strong remarks in its judgment. The bench, which had Justice D.Y. Chandrachud and Justice Hima Kohli, said that whether a woman is habitual to sexual intercourse is irrelevant for determining whether she was raped. It said that the test is based on the incorrect assumption that a sexually active woman cannot be raped. The court also said that the test has absolutely no scientific basis and neither proves nor disproves allegations of rape. It in fact said that the test instead re-victimizes and re-traumatizes women who have been sexually assaulted. So the Supreme Court said that this test must not be conducted and said that any person who conducts two-finger test, of course it's doctors who usually conduct it, while examining an alleged survivor of sexual assault shall be guilty of misconduct. It also directed the central and state governments to conduct workshops for healthcare providers, informing them of the appropriate procedures to be used and adopted while examining survivors of sexual assault and rape. The governments were also asked to review the curriculum in medical schools to ensure that the test is not prescribed as one of the procedures for examining survivors of sexual assault and rape. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.